Hello everyone, I am Sohini Chatterjee, an intern at ubAdvocate. I will be discussing contractual liability of the government. Article 298 of the Constitution of India talks about the power of the union or the government to carry on trade and enter into contracts for the purpose of selling or purchasing any property. As per Article 299, all the contracts which are made under the executive power of the union or the state should be made in the name of the president or the governor respectively. If a contract is not made under the president or governor's name, such a contract will not be considered as a government contract. Further, all the terms of the contract should be enforced on their behalf a person who has been authorized to act on their behalf. And now, under Clause 2 of Article 299, the President or the Governor can't be held personally liable for the non-performance of the contract. Thus, they are immune to any personal liability for the breach of contract because the contract is made in their name only, but they themselves don't perform the contract. We know that the terms of a contract are governed by the Indian Contract Act. The Supreme Court held in the state of Bihar versus Majid, which is a 1954 case, that since government contract is also a type of contract, it will be governed by the provisions of the Indian Contract Act. It must also adhere to the requirements of Article 299 Clause 1. Now moving on to the next case, that is Bhikara Jaipuria versus Union of India 1962. The Apex Court laid down that a formal written contract is mandatory for entering into government contracts. The judicial approach to Article 299 has attempted to strike a compromise between two motivations. Number one, on the one hand, to defend the government against unauthorized contracts, and number two, on the other hand, to protect the interests of naive and unwary parties who enter into contracts with government employees without following all of the Constitution's procedures. Article 299 Clause 2 immunizes the President as well as the Governor from incurring any personal liability if anything goes wrong in terms of a government contract. But does that mean the government in totality can go scot-free? No, this isn't the case. Many courts have held that in case the government has derived any benefit from a person by an agreement which does not fulfill the requirements under Article 299, the government will be held liable for compensating the other party under Section 70 of the Contract Act, and such a contract will be deemed to be a quasi-contract to the extent the government gets the benefit. This has been provided to protect an innocent party from suffering loss. The Supreme Court decided in State of West Bengal versus Messrs. B.K. Mondal and Sons that if Section 70 is declared inapplicable, it will result non-extremely unjustified situations and may even obstruct government operations. The government, like ordinary persons, should be subject to Section 70's provisions. It can be concluded that a government contract is the same as an ordinary contract, but under this contract, one of the parties is the central or the state government, and in addition to the requirements of the Indian Contract Act 1872, the provisions of Article 299 of the Constitution of India is also to be followed. Otherwise, the contract will not be a valid one. Implied agreements can't become a government contract Although strict compliance with the provisions of Article 299 is required to be fulfilled, but in cases where there is unjust enrichment, the court allows the party to recover such benefit provided by them. I would like to thank Jeevan Prakash Sir, Advocate on Record, Supreme Court, for providing me with this opportunity of making a presentation of my choice as Task 28 of my internship. Thank you.